Hi, thank you for joining our webinar today. My name is Jessie Peterson. I'm the Director of Education here at SunRay Construction Solutions. SunRay secures $10 billion annually for GCs, subs, and suppliers. We are a national construction document service. Today's webinar is conducted by the incredible Shannon Bell, a Colorado construction lien law expert. Today's webinar topic is Beware of Lien Loopholes and Timing. So without further ado, I'd like to introduce the fabulous Shannon Bell.
Well, thank you, Jessie, and thank you to all of you who are tuning in. A couple of preliminary matters. If you have any questions today, please go to the GoToWebinar chat box on the right. We will answer all questions at the end. Do please respect your customers. Do not include names or company names in the questions. It's helpful for all of us if we keep them a little bit generic. And if you do not have the chance to get your question answered, you are always welcome to reach out to me after the program. I'm going to give you a quick outline of what we are going to cover today. I'm going to try to move through at a pretty quick pace. I want to try to make this a little bit as interesting as possible, filling out forms on your mechanics liens. And hopefully, for those of you who have been doing liens, you're going to pick up a couple of new nuances, things you have not thought of that are going to help you protect your lien rights. Those of you who are new, there's going to be enough basics that it's going to give you a roadmap of what you need to protect yourself. What to expect in today's presentation. What is a mechanics lien? We're going to go through the form. How do you perfect the lien? That's what we call it here in Colorado and most states. It's called perfecting the lien because these are statutorily created remedies for you, and most courts are going to expect them to be perfect or nearly perfect, thus perfecting the lien. Timing, really important on the, pay attention to the timing to protect your lien rights because timing is everything. Certain exceptions on some of these rights and these notice requirements to be aware of. For those of you who do some work on multi-ownership properties, we're also going to touch base on some of the remedies available to you there. And of course, we're going to help you out a little bit if you have not perfected your lien, just looking at what some of your other remedies are. Let's just jump right in. We're going to start with the basics, the mechanics lien. Well, what is it, right? A lot of folks hear about the mechanics lien. It can be a hammer to help get you paid. However, and as you're going to notice, and we're going to go through on today's presentation, they have to be done correctly and they have to be done on time because it is a tool that's going to allow a contractor or a general contractor, subcontractor, material supplier, really anyone who's doing an improvement to real property. It's allowing a mechanism for you to secure the debt that is owed to you by placing a lien on real estate. And what this is allowing, and look, most of you who are doing work, you're delivering materials to a property, to the property is by the owner, often do not have a contract with the owner. What this is allowing you to do, it's allowing you to jump over the general contractor, whomever has hired you, to go directly to the owner and to secure that your right to get paid on that real property. Well, guess what? In the United States, we hold property ownership pretty near and dear. There's a lot of protections associated with property ownership. So in order to get that lien, you are encumbering somebody's real property. You're putting a cloud on the title of their ownership, and the statute allows you to do so. Each state's going to have very specific requirements, and it's important that you follow these requirements in order to get that right. And just a note, I am going to be focusing on Colorado law today. A lot of states are pretty similar, but there are nuances from state to state. We're going to come back to that a little bit later in today's presentation. Okay, so we've talked about what a lien is. Well, what isn't a lien? A lien is not a guarantee of payment. You can do your lien perfectly, you can get your notice out, you can get it recorded, you still may not be paid on that lien. Lien has, depending on what type of project it is and the timing of it, a lien often will have super priority, meaning it's going to jump in line in front of every other encumbrance on the property, including most likely their actual deed of trust for the mortgage, in particular if it's new construction. If you're later on, it's a remodel, you may not be able to jump in line, and it may not be worth it to foreclose on that lien. We're going to talk about the foreclosure in a little bit, but it's a legal process where you're taking out any encumbrance in front of you. So you basically get the property for a reduced amount. Owners don't want to give that up. That's why they're going to pay oftentimes to get rid of that lien. But if you don't want to do that process, the lien's not going to be worth anything. So it's not a guarantee of payment. It is not something that can be rushed. It is not something that can be done sloppily, because otherwise it is not going to protect your rights, and it may not make you whole. Attorney's fees are not part of the lien statute. In other words, if you hire an attorney to help you with it, you file your lien, you foreclose the lien, you get paid on your lien, you do not automatically get your attorney's fees paid to you as part of a lien claim. So just be aware of that. I'm also going to share with you in a little bit kind of an unfair twist on attorney's fees, just so you have a little foreshadowing there, something to look forward to. Okay, so we're going to spend some time now on the form, because this is how you're going to perfect your lien rights. It's very important to do this correctly. Well, guess what? I think it's a little bit confusing, but the lien form, there's actually two parts. There is the notice of intent to lien and the lien itself. For those of you who are not as familiar, maybe you are, here's what it looks like. You have, and these can be done one of two ways. You can do this with a front and back, so it's one page with that statement of lien on the front and the notice of intent to lien on the back, or you can do it as two separate pages, statement of lien page 1, notice of intent to lien page 2. But this is one document. Even though you have two different titles on these two different pages, it is one document. And in order to perfect your lien, you have to do part 1, which is your notice of intent to file a lien statement. That does not mean you just do this page 2 over here. You have to complete all of page 1, and we're going to go through and fill out most of page 2 on this notice of intent. That's part 1. Now, how do we perfect it? And why do we have to perfect it? A perfected lien is one that is valid in notice, time, and amount. You're going to hear me say that so much today, you're going to probably be sick of hearing notice, time, and amount, but my hope for you is you're going to walk away from this presentation and you're going to have in the back of your head notice, time, and amount, because that is the primary things you need to do to perfect your lien. Do make sure that you have all the proper information in as part of the notice, that you get everything out on time, and you have the amount, the correct amount listed that you are owed as required by law. Well, how do we do all that? You got to fill out the form. Again, we're going to walk through that in a minute. You're going to send the notice of intent to lien. That's that notice. So it's part 1 of the 2-part lien. Part 1, you got to give everyone notice. Hey, I'm owed money. I'm giving you notice. I'm about ready to record a lien. Got to get that notice out first. And you have to send that notice to the owner or all reputed owners. And if you are not the general contractor, to the general contractor. Once you send that notice out, you've told everyone, I'm owed money. I'm going to record a lien if you don't pay me. No one gets back to you. Then you record that completed lien with the appropriate county clerk. That is going to be the clerk and recorder of the county in which the real property where you performed work is situated. Let's take a look at that lien statement. So we're on page 1 of 2, statement of lien. This is everything you still have to do for part 1 to get the notice out. On the front of the page, you're going to have to identify yourself. It seems real redundant, but yep, you put yourself in all over the place. You're going to start with who you are, the lien claimant. You're making the statement of lien. You have to, again, identify your address. Check the box. Are you a subcontractor or a principal contractor? Well, there's not a box here. If you're a laborer or a material supplier, on that you could do subcontractor, or you can leave it blank. That's not as critical, but try to be clean and do that. You're going to, again, list who you are. You're the one who's furnished the materials. Then you're going to go again that the lien is on behalf held for and on account of you, the lien holder. Again, I get it. 1, 2, 3, 4 times you're saying who you are. That's before you even get to the signature. And we're just on page 1 of 2. But go through the redundancy. put it all in. Identify the general contractor. I've highlighted that here in blue for you. It's important to do that. Even if you are the general contractor, you're claiming as a general, now you're going to list yourself again. So you're going to be there even more than just a subcontractor. Identify the owner of the property and the property address. So you're going to, this is going to come up here. Here's who the owner or reputed owner. That can be a little odd. You've got your title owner. That's who the clerk and recorder shows as owning the property. But a reputed owner is someone that claims ownership. Oftentimes you'll have someone who's going to buy the property who hires a general contractor, but the title is still held by a developer. You're going to want to identify anybody who is on that chain of title as owning the property or claiming to own the property. That's what that means by that reputed owner. You're going to go in and identify the property, put in the street address, put in a legal description of the property. Remember, notice, time, and amount. We are all right now in the notice. You're providing notice. Going back a page. Notice, here's who I am. Notice, here's who the general contractor is. Now you're getting to notice. You're giving notice to the owner. Here's who the owner is. Notice of what the property is that is being subject to that lien. It is try to get that legal description, because what you are doing here is you're also now putting in information to give the clerk and recorder notice of the property at issue. The owner is going to go into that grantor grantee index because you want the clerk at the clerk and recorder's office to have sufficient information to get this recorded in a way that it's going to show up on the property records for the property where the work is performed. Axiom of law, pretty common sense here. If you don't name the property, that's probably one of the most important pieces, right? To name that property, because a lien cannot attach to property other than that which is mentioned in the lien statement. So if you name the wrong property, you're not going to protect your rights. If you don't name any property, you're not going to protect your rights. Make sure you get that property identified. And then one of the next pieces of this is how much are you owed? I'll pause here for a minute. This is important. Do not overstate the amount that you are owed. An exaggerated lien will be void and make the claimant, you the lien claimant, liable for court costs and attorney's fees that the owner incurs in getting rid of that lien. If you're paying attention, remember a few minutes ago, I talked about you don't get your attorney's fees paid, but there's an unfair nuance to that. Well, here's the unfair nuance. Under the lien statutes, at least here in Colorado, as a lien claimant, you're legitimately owed money, you legitimately have not been paid, you record a lien, you file a lien, you get paid on that lien, you do not get your attorney's fees under the statute. Maybe you get them under a contract, but not under the statute. Whereas an owner who has had an excessive lien paid on their property automatically get their attorney's fees if they're successful in demonstrating it was overstated and getting that removed. So be aware of it. It's important to put the correct amount in. Well, what do I mean by that? Or if you're going, well, gosh, Shannon, that sounds easy, but we don't know, there's a dispute. Let's say you have a contract for $100,000. You've done change orders for $20,000, and you haven't been paid anything. Your claim is we are owed $120,000. And the owner says, well, I didn't approve those change orders, or I don't like those change orders. The fact you have a legitimate dispute as to the amount you're owed is not going to trigger this excessive amount and is not going to make your lien facially invalid, meaning on the front of the document, without getting into too much detail, it's invalid. Where you're going to see this exaggerated lien is a knowing and willful overstatement of the amount you are owed. So looking at that scenario, you have a contract for $100,000, but you've been paid $50,000 of the contract. If you record a lien for $100,000, knowing you've already been paid $50,000, that's going to trigger that type of exposure for an exaggerated lien, because you're not owed $100,000, you're only owed $50,000. Be aware of that. That's part of your, remember, notice time amount, that's the amount piece of it. make sure you put in the right amount and make sure you put in amount. And then finally, sign and notarize. Phew, well, guess what? That's just page 1. Now we're going to flip to page 2. Page 2. Now we're verifying that notice element. And you're putting, this is just all your mailing certificates. You're putting in here, hey, I'm the lien claimant. I'm telling everyone, look on page 1, look at the front side. Here's who I am, the work I did, where I did work, and how much I am owed. And I'm going to tell everyone, I'm telling everyone, here's who I'm giving notice to. So that's just right here, saying I'm giving you all notice. You're sending that notice to the owner or reputed owner or their agent, and there may be 2 addresses, there may be 4 addresses. Every address of an owner, you're going to put in here. You're going to sign it, and you're going to make sure you complete the date that you're sending this out, and you're going to have your signature notarized. Signature notary, signature notary, signature, no notary needed for the top part. On the bottom ones, these mailing certs, sign and notarize. And you're going to send these by certified mail. Return receipt requested. You may also have them personally delivered. You can hand deliver them. If so, you're going to change that certificate of service to represent how you're getting it sent, how you're sending it. And you're going to do the same exercise with the contract, the principal contractor and their agent, and all addresses, the date you are sending it, sign and notarize. Now I've put in here, you're going to send it to the owner, contract, sign, notarize, certified mail. My practice is I also do regular mail. Why? Because oftentimes when you have a general contractor, you have an owner who is getting behind, they know this is coming, they get real nervous when they get certified mail. They don't want to sign for it. So if you send regular mail, and it's not returned, that's good evidence if you have to go to court to foreclose on this, that they rejected that certified mail. You sent it certified, you did what you're supposed to, but you also did regular mail and that was not returned, demonstrating that was a good address for the owner or the contractor. Little bit of belt and suspenders there. But beware, and this is one I see people do an awful lot. Do not sign the bottom part, this affidavit of service, when you're doing your notice of intent. So remember, right now, going through the front and back, we're doing our statement of lien and everything. We're filling out that front page. We're filling out the back page. All of this is just your notice of intent. Even though the front page says statement of lien, the front and back is your notice of intent, because what you have to do is you have to mail that out. Remember, so part of that timing, notice and timing, you're mailing that out to the owner. You're mailing it out to the general contractor, and you are saying, if you do not pay me in 10 days, in Colorado, 10 days is a magic number. Different states have different notice requirements. So if you're doing work outside of Colorado, check that state statute. A lot of them are like 10 or 14 days, so they're pretty close. Once you send this out, the owner or the general contractor has 10 days to get you paid. And you're sending that notice and you're saying, pay me in 10 days or then I will record. The bottom part on this page 2 or the back of that statement of lien is what you fill out after waiting the requisite 10 days. And you're attesting to everyone, I waited 10 days, and now that that 10 days has expired, now I'm going to record. Very important to hold on to that. So let's take a pause here, because this is just the form. We're only talking about the form, but yeah, hopefully you can see how important it is to go through all that information. This is can be a very expensive piece of paper to protect your lien rights. Before mailing it, before going to the post office, do a double check, pause. Do you have the correct information? Are you using the correct dates? Have you signed and notarized that document in all of the right places? You need all of those signatures. And if you've done all those things, you've made sure everything's correct, keep the original. You're mailing out a copy, because what are you going to do on that original After the 10 days have expired, you're going to go back to this affidavit of service on the bottom and complete that after the expiration of 10 days. And it even tells you right here, the notice of intent was served as evidenced by these certificates of service above at least 10 days. So if you read it, it's really pretty self-explanatory. I've had lots and lots of issues on both sides where I've represented owners. We've gotten liens thrown out because people who don't know better fill out that affidavit of service at the time they mail it. That is, can lose your lien rights if you do not respect that. After that 10 days has expired, then you fill out that affidavit, and that's all you're doing. Once you mail it out, you don't have to mail out anything else. Then what you're going to do is you're going to fill out that affidavit and take that original and have it recorded with the appropriate clerk and recorders. A couple of little tools for you, because it's not always obvious who the right owners are, how you find that information. Are you sending it to the right people for the general contractor? If you have not visited the Colorado Secretary of State, it's a wonderful website for you. Here is the address up there. And when you click on it, it's going to take you to this homepage, and you're going to click on businesses, trademarks, and trade names. I tried to do a little video for you to demonstrate how you can get there and the information, but I think it might skip. I apologize. But you're just going to go into your search engine of choice and type in Colorado Secretary of State. It's going to bring you to that homepage. It jumped. I apologize, but it's going to go into a business search, and you're going to type in the business name. And again, I apologize, it jumped around a little bit, but you're going to type in the business name. It's going to show you a screen of the information, and you click on it, and it's going to ultimately bring you to the summary page. I did Kelly Law Partners. On the summary page, it's going to show you the principal office street address, and it's going to show you the registered agent's name and address. That's great information. If you're going to do the general contractor, send it to their principal address and send it to the registered agent. Oftentimes, property is owned by an LLC. You can get the LLC's business address and registered agent. Great tool to use to fill out the mailing certificates to make sure you're getting notice to all the right folks. Ownership information, you're trying to find that legal address. Most folks are doing work, they've got the street address for the property, but they don't know how to get the legal address, that legal property description. The clerk and recorder websites are very helpful information for you. Here's the one for the city and county of Denver. You can go in, they'll have screens, they're all a little bit different, so play around with them. Well, you can go and search for records. Denver, you search for records, and then it's going to bring you again, search for records, and you click twice, and then you can start looking oftentimes by street address. Sometimes it's not that easy. Sometimes they're going to want you to have the grantor grantee's name. If you don't have that, another really helpful tool is Zillow. So if you go into Zillow, you go into type in a property because you've got the street address, and in Zillow, you can go into facts and features. Under facts and features, you'll see here in details, it has the parcel ID number. And most clerk and recorder websites will have a place for you to plug in a parcel ID number, and you plug that number in, and now you're going to get the owner name. You're going to get all of the recent title owner name, so you have the owner information to put into your certificate of service. And the other way to get into this, not all, but some properties will have this additional feature in Zillow, which is one of my favorites. You go into Zillow, you go into market value and the tax history, and under the tax history, here's the assessor information on the county website. You click that, and it's often just going to bring you right in to the clerk and recorder website for this particular piece of property. It's going to populate that parcel ID number for you, and you're going to have all of that ownership information and legal property description right at your fingertips. So just some helpful tools for you. Okay. Notice, time, amount. We've talked about notice. We've talked about amount. Now we're going to talk about time. Timing is everything. I told you in the beginning, it's called perfecting a lien because it has to be perfect. Now, maybe I exaggerated a little bit. The courts will give you some leeway maybe on the amount if it's not an excessive amount. If you've If the owner has gotten notice, even if maybe it wasn't exactly the right address, as long as you can demonstrate actual notice, where the court will not give you any leeway is on timing. If you blow your timing on your lien rights, it is forever gone. It is critically important to know the timing. And what do I mean by that? In Colorado, you must record. And remember, you cannot record until you've given notice and that 10-day notice has expired. But in Colorado, you must record that lien within 4 months of the day on which the last labor or materials was furnished. If you are a material supplier, it is when you deliver the last load of frame timber or lumber or material, your last delivery. If you are a contractor or a subcontractor, it's the last day where you performed substantial work associated with the contractor's scope of work. Going back 2 months later and like delivering some screws to try to extend the lien rights is not going to work. Punch list items is not going to expand or extend the last date. It's really the last date of substantial work related to the contract. You gotta serve that notice 10 days before the 4-month deadline. In Colorado, I just want to highlight, it's 4 months. It's not 120 days, it's 4 months. If you did work on January 11th, that's the last date you did work, the last day you delivered materials. You're going to go, so you go February, March, April, May. May 11th is your 4-month deadline. So you want to do that notice out on May 1st. You got to get 10 days before that 4-month deadline. Something to note here, look at your county requirements in advance. Most counties, excuse me, will allow you to file the final statement of lien online, but not all do. Some that will allow you to do that, you have to have an account, you have to pay for an account, and there's some steps associated with that. If you want to do it in person or have a runner do it in person. Now, even though we're well past COVID, it's affected a lot of clerk and recorder's offices. Some of them are only open 3 days a week. You want to know what the requirements are to assure that on the day you want to record it, you can record it, that you can go in person or you can do it online. So look at what that county requires in advance. And then again, excuse me, assuming you've done your notice, you've got it recorded, and within that 4-month period, you have to initiate your lawsuit within 6 months of the last work or substantial completion of the project, whichever is later. Lots and lots of things to put on your calendar. So let's take a quick look at how this would work. I use January 11th, that's a substantial completion. Let's say it's substantial completion of the project and it's the last date you did work. And we counted that May 11th. So if you want to get that lien, you have to get it by May 11th. You're going to mail it on May 1st to do your 10 days. Well, if anyone is looking at this, they might be going, well, hold on. That is Saturday. That May 11th is on a Saturday. Is that a problem? Yeah, it is. You're not going to be able to record your lien on a Saturday, a Sunday, or a court holiday. If someone were to look at this and follow this chart and go, oh, well, I'm good. I did my 10-day notice on May 1st. You've lost your lien rights because you cannot record 10 days later. What's going to happen is you're going to be able to record on May 13th if you mail it on May 1st because you can't record on that weekend, and now you have just blown that 4-month deadline. It's important to look at these dates and look at them early. Well, what are some exceptions to all of these rules I'm telling you about, and to some things to be aware of? If you are doing a project for a governmental entity, you're doing work on public land, you do not have a lien right. But don't stress yourself out about it because you don't got it. What you're going to be looking at there is a bond claim. If you're a general labor, just like a day labor, you only have 2 months, you don't have 4 months. If you are under a contract, maybe you waived your lien rights in the contract. And so if you do a notice of intent and they call you up and the general says, look at your contract, you waived the right to lien this property, take a look at that. They might be right. And if they're right and that there's a waiver of your lien rights and you record it anyway, you may be in that position where you're paying attorney's fees for the other side to force you to release that lien. I'm going to skip over homeowners exception and come back to that in a minute. Notice extending. I want to just go back to this chart. A notice extending is going to buy you time. If you are in this scenario I was walking through and you're like, oh, phew, I did my 10-day notice on May 1st, and on Monday the 6th, you go, uh-oh, I can't record within 4 months. You can do a notice extending. And the nice thing about a notice extending, it is a document that you record with the clerk and recorder's office. You do not have to mail it to anyone. And what that notice extending is going to do, it's going to extend your time to record your lien rights. So long as you file your notice of extending within the 4-month period, you've just bought yourself time. It's going to extend your lien rights associated with the end of the project, the completion of the project. Really good tool to have in your tool belt. Be aware on that substantial completion. The lien rights are going to be, the foreclosure is going to be tied to the substantial completion. If a project is abandoned, that substantial completion is going to be deemed 3 months after abandonment. Okay, I told you I was going to skip over homeowners exception. I'm going to come back to that. Just be aware of this. The homeowners exception only applies to residential property. If you have a homeowner who hires a general contractor to do a project, let's say for $500,000, homeowner pays the general $500,000. General doesn't pay that $500,000 downstream to you, the subcontractor. You go to record your lien, homeowner goes, I paid it in full. You don't get to encumber my property. Go chase the general because I already paid them in full. That is a valid defense to a lien in the state of Colorado. If they have a legitimate homeowner's exception and you record the lien anyway, or you try to pursue, you now are going to probably pay that homeowner their legal fees to get that lien released. Something just to be aware of, I want to touch upon this fairly quickly, liens on multi-ownership properties. If you are doing lien on a townhome, condo, things like that, you've got some different lien rights. You can do a blanket lien. That's going to be a single lien claim for the entire debt against all of the units of properties. And this is going to be valid where you cannot definitively or readily divide and apportion your work. You're going to tend to see this more for the excavators, ones who are doing site preparation, asphalt work, where you really can't say, I did this amount of work for this particular unit. There's a several lien. You can do separate liens against all of the units of property that benefited, but it has to be in proportion to the value of the work you or an entire lien. These are real tricky. You can do an entire lien on a single property in this multi-unit development, only if all the units or properties are solely owned by the debtor and the cost and materials cannot be apportioned. So what's the risk here if you're doing these multi-units? Units start getting sold, you don't have your lien rights, your lien recorded, and you can apportion it. You're going to start chipping down what you can recover. If you are going to do one of these multi-ownership liens, it's really important to describe all the lienable properties, because remember that earlier caveat, you can only lien property that is listed. If it is possible to allocate the value of your work, you're installing windows, you did 20 windows on this unit, you can approximate the materials and the labor for that. Because if the court finds it was capable of being apportioned or allocated and you didn't, the court can jump in and make that apportionment for you. It's real risky to have a court make those decisions for you. And something helpful is to keep good records. If you're going to do that, it's going to help you prove your lien rights. So as we're wrapping up, I said, look, this is all this scary stuff, right? You've got this timing, you got to notice, you got to do the right, notice it in time, do the right amount. Maybe you blew it. You didn't get that lien recorded in time. All is not lost. If you've lost your lien rights, because the lien rights, they're really giving you an ability to go after the home owner, or the, if it's commercial, the owner of the property, if you don't have a contract with them. If you've lost that ability, you always have those common law rights for breach of contract, unjust enrichment, or any other common law claims, maybe an account stated, but that's only to be against the party that hired you. So again, keep that in mind. One thing I want to notice, though, or share with you, sorry, I shouldn't say notice, I'm saying notice time and amount, getting notice in your head, but just something to keep and aware. And this is more on that timing. It's so important to do these lien rights early. Don't wait until the fourth month, if at all possible. I think so many of my clients have been victims of an owner or a general contractor saying, the money's coming, the money's coming, I'm sorry, just give me a few more weeks. And we get lulled into that sense of security. And it's not that the general is lying to you, it's not that the owner is necessarily being deceptive. They legitimately are waiting for another funding, or they're legitimately waiting to be paid by the owner. But unfortunately, 4 months goes really, really fast. So get out there in front early and protect your lien rights. Don't wait till that fourth month if at all possible. And that's just part of my summary. We really pay attention to those deadlines. If you're in different states, spend a couple of minutes to check the nuances from state to state. Keep good records. You want to be able to prove the amount you are owed. Be careful with those forms. And again, just do not sit on your rights. So with that, I'm going to thank you for paying attention, for dialing in today, and open it up to any questions.
Well, thank you so much, Shannon. You really did a great job of explaining the lien process and the nuances there, so I do appreciate it. We do have a question that has come through, and I think this is talking about one of your your later slides that you had. It says, if you're contracted by a condo association to do work on the common area space, would I file a several lien or an entire lien in that situation?
You would do a blanket lien in that situation because it's
Perfect.
benefiting the entirety of the property.
Wonderful, thank you. Another question that came through, it says, will my lien take priority over existing mortgages or other liens?
Great question. Thank you for asking, because it depends. What will happen, you tend to have a better opportunity for a priority position if it's new construction. A lien is going to relate back to the first work done for the benefit of the project, for the scope of work that you are performing. So for example, if it is a home, a new home, the new homeowner is going to go to their lender and say, I want to take out a mortgage, I need a construction loan, I want to build my dream home on my property. The lender is not going to make that decision until they have an idea of what the property looks like. Is the loan going to justify the home that's going to be built? Is there going to be enough equity to support that loan? So in order for the homeowner to do that, they're going to typically have to do a soils report. They're going to at least have a preliminary architect design. That work is going to be occurring prior to the construction lender, or when it's converted to a mortgage, recording their deed of trust. So in that scenario, everyone who does work for that project get to jump back in time to the very first work. So that soils report, that in preliminary architectural design. And in that case, the lien claimants, all lien claimants have super priority and are going to jump in front of the mortgage or that construction loan. Now, all lien holders are going to have equal rights. So if you've got 4 or 5 lien claimants, they all have super priority, but amongst each other, they're going to have equal priority, and they're going to be fighting really for a pro rata share. It is less clear when you are doing maybe a remodel. If you're doing a remodel, it's a brand new project. In that case, you most likely are not going to jump in front of the existing mortgage, because you did that work with notice of that pre-existing encumbrance on the property.
Okay, wonderful. Another question that has come through, is monthly service work considered lienable in Colorado?
Generally, no. If it's
Okay.
just, yeah, like like for example, if you're going in and doing maintenance to HVAC units on a commercial property, that's not deemed typically an improvement to real property, such as that it's going to trigger a lien right.
Yeah, it would have to be tied to the construction job portion of it. Um,
Correct.
okay. Another question that has come through, it says, can lien amounts be amended if they pay partial or if more work took place since first placing the lien?
Absolutely. You can always come in and do an amendment to a lien. And in fact, it is good practice if they have paid you to go in and to amend that lien notice.
Okay. And then another question that has come through, it says, on a commercial job, if the GC happens to have a bond as well on that, can you do a lien and a bond claim on that job?
It's probably going to be dictated by the contract. Often the contract is going to set forth what your rights are. And I have not seen a scenario if it's a commercial project not on public land, but they just have a bond. You're going to be better off doing the bond because a bond is a more streamlined process
Okay.
to get paid.
Okay,
But
great.
I'm not, yeah, again, I'm not aware of anything that would prohibit you from doing both unless it's set forth in the contract that says if you, that you waive lien rights and your owner rights are through the payment bond.
Okay. Another question, how long does the notice extending extend your deadline to?
Generally 2 months after the date of substantial completion of the project.
Okay. All right, perfect. I think that's all the questions that have come through. Oh, another one just popped up. If there is a valid homeowner exception, would you then have to file a lawsuit against the GC instead?
Yes, yes. If
Okay.
there's a homeowner exception, you've lost all lien rights, but you have not lost your common law rights, the ones breach of contract, unjust enrichment. You
Right.
may even have in Colorado, in particular, if the homeowner exception has come in, you probably have a trust fund claim against a general contractor. That's a whole nother hour I could talk about that. But basically, if the general contractor has been paid in full, they are holding those funds in trust for everyone downstream, and that's a way you can go after not only the general contractor but individual owners of the general contractor entity, and they may be found liable for theft. Really big hammer.
Okay, great. All right, so that's all the questions that I see that have come through right now. If anyone does think of a question that hasn't been addressed, please feel free to reach out. We'll be sure to answer any questions to the best of our ability as soon as possible. All right, so who is ready to win a gift? We're testing your knowledge. If you can answer these questions correctly in the chat, we'll go ahead and send you guys a little prize. So take a look at these. I know that Shannon has gone through this. And we've touched on this, so take a look, see if there's anything that you know the answer to, and let us know in the chat section, and I'll send you guys out a gift. Can you go to the next slide for me, please? All right, so here are some of the SunRay resources to help you stay organized, know your deadlines, and secure your lien rights. Go ahead and scan that QR code to access these incredible resources. You've got deadline calculators, the project information sheets. Those are amazing to keep you and your team organized, get the information that you need right off the get-go when you're first signing these contracts, and know who you guys are working for and all of the participants upstream. Like Shannon touched on, each state has its own set of lien laws, rules, deadlines, documents that are required. So if you go onto our website, you can click on which state you're going to be doing work on, what your role is on that project, and it's going to tell you exactly what documents are needed and what your deadlines are to get those sent in. So check that out, and it will definitely give you that information. All right, next slide, if you don't mind, please. All right, if you want, go ahead and check out this new service that SunRay has. It's SR Receivables. We'll be helping you guys with your collections. So if you do need some help, please reach out to us and we'll be able to see if that's something that we can help you with. All right, next slide, if you don't mind. All right, and then if you don't mind, give us a quick review on Google. We really appreciate the feedback. It helps us get better information and content out to you of what you guys are looking to learn about, and we really appreciate it. So if you don't mind, give us that review. And then with that, that is all we have for you guys today. I want to thank everybody who did attend. We hope to see you guys at our next webinar. Thank you again, Shannon, so much for all your time and input on this. We really appreciate it. And I hope you all have a wonderful and beautiful sunny day. Thanks again, everyone. Thanks again, Shannon.